Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, do any of you have friends who are just gluttons for punishment? You know, the type that can never, ever get out of their own way. It just seems that they constantly are running into trouble, and it almost is always caused by their own stupidity. Well, there are states that act in a much similar way. Take, for example, I don't know, how about New York? Yeah, that's right. Because for those of us who've been geeking out on the channel for a while now, we know this summer the state of New York took a horrible beatdown at the hands of the United States Supreme Court. What did they do? Did they learn their lesson? Oh, no, of course not. They doubled down, they tripled down, and they passed even more oppressive gun laws. Well, that has led to a whole new slew of litigation, which even has the United States Supreme Court calling New York to the principal's office, as we talked about in this video right here. Well, today we're going to have to talk yet again about New York because they are definitely setting new standards when it comes to unconstitutional gun laws. So let's spend a few minutes today and talk about when your gun laws are so bad they violate 2 constitutional amendments. Okay, so the case we're talking about today is a case called Spencer v. Nigrelli. It is filed in the Western District of New York. This is a challenge to certain aspects of New York's Concealed Carry Improvement Act of 2022, or what we have referred to as a big, gigantic middle finger to the United States Supreme Court in response to its Bruin ruling. Now, the issue that's being brought up in Spencer v. Nigrelli is New York's new restriction on an absolute ban of carrying any type of firearm in houses of worship, churches, synagogues, or any other worshiping type location. New York's new Concealed Carry Improvement Act, which had no improvement to it whatsoever, basically tried to regulate the state and say that almost the entire state of New York is now a sensitive area, which means you cannot possess a firearm. The problem, of course, is that if you want to go to church, you then have to choose between, do I want to exercise my First Amendment right of freedom of religion and trade that for not getting to exercise my Second Amendment right, or my God-given right of self-preservation. And in this country, even in the year 2022, no citizen should be given the Hobson's choice of having to choose between exercising one constitutional right in sacrifice of another. Well, this case was challenged to the Western District of New York and assigned to the Honorable John L. Sinatra. I love that name. And yes, this judge is definitely going to do things his way. You see, because Judge Sinatra has issued a preliminary injunction against the component of New York CCIA, which prohibited firearms in all houses of worship. That portion of the law is not in effect as of today. This comes from a well-crafted 36-page opinion authored by Justice Sinatra that was published yesterday. I'm going to share a few portions of it because I really got to give it up to Governor Hochul here, because we routinely see terrible pieces of gun control legislation which are usually violative of a constitutional amendment. Rarely, if ever, do we see a piece of gun control legislation that not only violates one, but actually 2 constitutional amendments, because Justice Sinatra in this case has specifically ruled that New York's provisions as it relates to these firearm restrictions in churches and other houses of worship not only violates a person's Second Amendment rights, not a huge shocker there, but it also violates a person's First Amendment rights on freedom of religion. Now, you can understand where Judge Sinatra is coming from this. In the very opening paragraph of his order issuing the injunction, the judge stated, as recounted in Hardaway v. Nigrelli, 8 days after the Supreme Court struck down New York's unconstitutional proper cause requirement for concealed carry licenses, the state responded with even more restrictive legislation barring all concealed carry license holders from vast swaths of the state. As in Hardaway, the complaint and motion in this case focused solely on one aspect of the new legislation, namely the portion making it a felony for such a license holder to possess a firearm at any place of worship or religious observation. That's right, New York was going to make the possession of a firearm at a church a felony. Now, here's the thing. Think about this. Churches didn't get to make their own policies. No, 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 no. In fact, the state made the policy for the church. It was the state stepping in and saying, we're hereby declaring all houses of worship to be a sensitive place without any input from any of these individual parishes. The judge summarized the plaintiff's very well-crafted arguments here as follows. Plaintiffs argue that this exclusion is a direct assault on First Amendment rights, in addition to running afoul of the Second Amendment, as this court recognized in Hardaway. They posit that New York now puts its citizens to an impossible choice. Forfeit your First Amendment right to gather for religious worship, or forfeit your Second Amendment right to armed self-defense. And that is exactly what the state of New York did, and that was done by design. The court went on to further state, ample Supreme Court precedent addressing the individual's freedoms under the First and Second Amendment to the Constitution dictate that New York's new place of worship exclusion is unconstitutional. As in Hardaway, the state fails the Second Amendment test as set forth in Bruin. And it fares no better with respect to the plaintiff's claims under the free exercise and establishment clauses of the First Amendment. Thus, and for the further reasons set forth below, plaintiff's motion for a preliminary injunction enjoining defendants' enforcement of this place of worship exclusion is granted. So, let me break that down into simple English terms for you. What the court is finding is it violates the Second Amendment on one grounds, as articulated by Bruin, and it establishes the First Amendment on two separate grounds. So congratulations, New York. You have found 3 constitutional violations encapsulating 2 constitutional amendments in one piece of legislation. It's amazing work. Now, why is this important? Well, obviously the temporary injunction is important because it allows New York citizens to enjoy both their First and Second Amendment rights simultaneously. What a novel concept. However, what's really important is let's remember what the test is to get a temporary injunction granted, because the test is that you must show irreparable harm. I think there's no doubt here that when you're giving the people the Hobson's choice between exercising one right or another, that's irreparable harm. But the second part of the test, and this is critical here, is that the plaintiffs must show a likelihood of prevailing. Judge Sinatra in this case has found that the plaintiffs in this case are likely to prevail not just on 1, not just on 2, but on 3 separate constitutional grounds, 2 of which fall under the First Amendment, 1 of which falls under the Second Amendment. And it's important to note that in the First Amendment and the Establishment Clause, which basically says that government cannot restrict the free practice of religion, not only are we entitled to our individual religious beliefs, but we are also entitled to practice our religion in whatever location is appropriate. We get to outwardly express our inner beliefs as it relates to faith and religion. The court was quick to point out here that the Free Exercise Clause protects not only the right to harbor religious beliefs inwardly and secretly, it also does perhaps its most important work by protecting the ability of those who hold religious beliefs of all kinds to live out their faiths in daily life through the performance or abstention from certain physical acts. And that is the critical component of the First Amendment as it talks about freedom of religion. Not only do we need to have the right to believe whatever we want to believe, we need to have the right and the ability to go practice our faith as we desire. And then in addition to the 2 violations under the First Amendment, Judge Sinatra also found a rather clear and obvious violation of individuals' Second Amendment rights, specifically in violation of the holdings of Bruin, when the court specifically stated, for these reasons, New York's house of worship exclusion violates the 14th Amendment in that it prevents law-abiding citizens with ordinary self-defense needs from exercising their right to keep and bear arms. Plaintiffs are likely to succeed on the merits of their Second Amendment claim. And of course, the citation was citing to New York Pistol and Rifle Association v. Bruin. So the bottom line is, New Yorkers, thanks to Judge Sinatra in the Western District of New York, you can go to church this weekend or any day, which you feel like doing, and yes, you can also exercise your other God-given right of self-preservation. Now, this means that this law is put on pause. It is stayed until the rest of the litigation to determine the constitutionality of the Concealed Carry Improvement Act is resolved on its merits. In the meantime, if you have any questions about this or anything else related to your Second Amendment rights, you know the drill. You can always contact us at WashingtonGunLaw.com, or, of course, you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Laws, to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.